Your Honor, I've received the complaint, I've received body cam video and the police report, Your Honor.
I do have one thing about bond I'd like to bring to the court.
Before I said it, or after?
I'm sorry, whenever the court.
Okay, well, I'll do it this way. Would the people's witnesses be available the second?
I will try my best, Your Honor.
Preliminary examination in person, July 2nd, 2024, 9 a.m. That is before Judge Harry. Yes, that's the bond.
When he was arraigned on June 13th, 2020, he called his friend, after he was told not to contact the victim, he called his friend to ask and gave the friend the victim's phone number and asked the friend to have the victim bond him out or to give him money to bond him out. So I'm concerned about the fact that he was ordered by the court not to contact the victim, and then he went ahead and did that prior to being bonded out on the 13th jail call. We had originally asked for a $250,000 bond in this case, and he was given only a $25,000 bond. So I am concerned about that.
But
Yes.
Mr. Crater.
Madam Prosecutor said she sent me, and I'm sure she did, but I've not received the audio of the jail call, so I cannot respond what's in it, what's not in it. What I can tell the court is that
There were calls made to the victim.
I can't represent that. I haven't heard them. I
guess I want to make sure I'm hearing what I think I'm hearing.
There were calls made to third party, telling the third party to contact the victim and giving the victim phone number to the third party. That was the same phone number in the police report.
Got it. Okay. Go ahead.
All right. So I cannot speak to the phone call because I've not heard the recording of it. What I can tell you is that I have yelled at my client, admonished my client if that did happen, he's not to have any contact with the victim. He's not to contact her or have a third party contact her in any way or fashion.
Well, why did he do that in the first place?
I don't know if he did or he didn't. It's the first I've heard of it.
Go ahead, go on.
He explained to me that he did make a call to his friend Ali to have funds released so he could be bonded out. That's what my client tells me. I don't have the jail costs.
So he's saying that he didn't have any contact with or direct anybody to have contact with the victim in this case. Is that what you're representing to the court?
If I could have a moment, Your Honor.
Yeah.
I'm sorry. Did you tell him to call the witness? Did you say that? Did you say that? So you did do that? Yes. Okay. Your Honor, after conversations with my client, he states to me that he did ask his friend to contact.
And just like that, the hearing starts like many others, routine, procedural, and calm. But don't let the polite good mornings fool you. In court, things can turn serious very quickly. The defense is requesting a preliminary examination, which basically means the court will decide if there's enough evidence to move the case forward. But the real drama here?
Witness in order to release funds to have him bonded out, Your Honor. He understands that he shouldn't have done that. I've yelled at him about that. I've explained to him that he cannot have any contact with the victim. He did not, on that jail call, from listening to Miss Blanche's details, tell her not to show up, tell her not to cooperate. So I would ask that he be allowed to remain out on bond, Your Honor.
Now things start heating up. The prosecutor is saying the defendant ignored a direct court order. According to the court rules, the defendant was told not to contact the victim at all. But the allegation here is that he tried to work around that rule by asking a friend to contact the victim for him. And in court, trying to get clever with the rules usually doesn't end well.
I hear you. I can't hear you. Sure, sure. And he wanted me to continue to say that he is fully employed, has a job waiting for
I
him.
understand that, but he's given certain conditions regarding his bond. And just willfully violates.